Absolutely.
Your Honor, let the record reflect I am showing opposing counsel what has been previously identified as Exhibits 39 and 40, found on page 124 and 127 of the record respectively. May I approach the witness?
You may.
Agent Riggs, I'm handing you what has been pre-marked as Exhibits 39 and 40. Do you recognize these?
Yes, I do.
What are they?
These are two of my email communications that I reviewed between both Mr. Sanchez and Mr. DuPont.
Are they in the same or substantially same condition as you last reviewed them?
Yes, they are.
Have they been changed or altered in any way?
No, they have not been.
Your Honor, the government moves into evidence what has been pre-marked as Exhibits 39 and 40 as Governments 2 and 3.
Any objection from the defense?
Yes, Your Honor, we object to what I believe is Exhibit 2 being the emails from page 124.
I'm actually going to take a moment here. If I could ask the government not to renumber the exhibits, because it makes it very difficult for both sides to track them, I'm going to refer to them by their pre-mark numbers.
The pre-marked numbers.
Pre-mark numbers. So that would be pre-marked exhibit number 39. What's the objection to that one?
Your Honor, the objection is to hearsay on the first email listed on that page.
The one that's indicated as 4:29 p.m.?
Correct, Your Honor. Your response?
Your Honor, this is not hearsay. The statements made by the defendant are admission by party opponent, as well as the statements made by the victim are admissible under 801 D2B. These are statements made by the defendant's employee within the scope of that employment, and the matters discussed specifically regard to their working conditions.
Based upon that justification, any further comment?
Your Honor, I would dispute the fact that this conversation is within the scope of Mr. Sanchez's employment outside of the presence of the jury, Your Honor. Mr. Sanchez was hired at DuPont Vineyard as an expert viticulturalist to grow vines. This conversation does not have anything to do with that. This is a personal dispute that the two men had.
Is it being offered for the truth of the matter statement?
Your Honor, these statements aren't being offered for the truth of poor pay or working conditions, merely for the effect on the listener being the defendant, and the effect being the deterioration of that relationship between the defendant and the victim.
Any objections?
Certainly, Your Honor.
Your Honor, the government moves into evidence what's been pre-marked as Exhibit 39 and 40 as Governments 39 and 40, respectively.
And there was no objection to exhibit 40, is that correct?
No, Your Honor.
Exhibits 39 and 40 are admitted. Please proceed.
Your Honor, permission to publish Exhibit 39 to the jury.
Granted.
Agent Riggs, I want to turn your attention to this email entitled "Following Up on Our Conversation." Can you tell me, as lead investigator in this matter, what did you observe from these emails?
I observed Ignacio Sanchez reaching out to Mr. DuPont and requesting better working conditions, better pay for the employees at the winery and vineyard. And consistently, Mr. DuPont is not abiding by those requests and saying that he will not abide and increase the pay or the working conditions. And as time goes on, the conversations become shorter and more aggressive.
How much time is elapsing between these emails?
Oh, it's a span of months.
Now, Agent Riggs, I want to turn your attention to what's been identified as Governments 40, and you're on permission to publish Governments 40 to the jury.
Granted.
Turning your attention to the email entitled "Dirty Little Secret." Tell us what you observed from this email.
In this email, I observed that Mr. Sanchez had actually began threatening Mr. DuPont, threatening to expose an affair that he was having outside of his marriage if he were not to comply with increasing the working wages and conditions. And Mr. DuPont's response was that, "I can shut you down quickly, son." You remember that.
You're on permission to retrieve Governments 39 and 40 from the witness. Now, Agent Riggs, I want to return to that interview we were discussing earlier. During that interview, the defendant mentioned any specific instances of a fight that he had with the victim.
Yes, in fact, he had mentioned that on the night of June 4th, he and the victim had gotten into a pretty heated argument, a shouting match at the winery, and that the sheriff's department was called.
What did the defendant tell you happened after the sheriff's department was called?
After the sheriff's department was called and both Mr. Sanchez and Mr. DuPont had finished their argument. Mr. DuPont said that he remained at the winery for a little longer and then went off to a Brazilian steakhouse.
Did the defendant mention if he was with anyone at that steakhouse?
He specifically mentioned that he was with his friend Eric Newell.
And what did the defendant tell you he did following that dinner?
He said after he had finished having dinner at the Brazilian steakhouse that he went home and did not leave his home for the night.
During that interview you had with the defendant, did he mention anything about owning any weapons?
Yes, he mentioned that he owned an 1895 Winchester hunting rifle, which can shoot .30 caliber bullets.
Did the defendant tell you where that weapon was located?
He gave me many different stories regarding the locations of this weapon. He first said that he no longer owns this weapon and instead used the past tense of I previously owned it, I no longer do. And then he changed his story later in my interview with him to say that he still owns the weapon, but instead it was in a cabin in Jackson, Wyoming from a duck hunting trip in 2018.
Now, with your training and experience, what did this indicate to you?
Well, I'm trained in deception detection as an FBI agent, and it indicated to me that the defendant was lying.
Did you review any forms of communication that confirmed your suspicions?
Yes, I did. I subpoenaed some Amazon recordings from Amazon. It was from an Alexa or an Amazon Echo that was found inside of Mr. DuPont's living room, and we recovered 250 recordings, and after analysis, we were left with one of substance.
Before we get into that one conversation of substance, let me just ask you, what is an Amazon Alexa?
Yes, an Amazon Echo or an Alexa is a smart home device that can be found in homes or any other location for that matter, and it would record conversations that you have. You would use the trigger word Alexa, and it would begin recording whatever you were saying.
Now, this one conversation of substance, when did it take place?
It took place on June 11th of 2019,
When did your interview with the defendant take place?
June 24th of 2019.
And this one conversation of substance, who was observed on that recording?
Bruce Cohen and Mr. DuPont.
Would you recognize that conversation of substance if I showed it to you?
Yes, I would.
Your Honor, let the record reflect I'm showing opposing counsel who has been pre-marked as Exhibit 13. May I approach the witness? Agent Riggs, I'm showing you what has been pre-marked as Exhibit 13. Do you recognize this?
Yes, I do.
What is it?
This is a CD copy of the Alexa recording that we recovered on June 11th of 2019.
Is it in the same or substantially same condition as when you last reviewed it?
Yes, it is.
Has it been changed or altered in any way?
No, it's not.
Your Honor, government moves into evidence what has been pre-marked as Exhibit 13 as Governance 13.
It's a CD.
Yes, however, we have a recording of such to publish to the jury.
But the exhibit itself is a CD.
The exhibit itself is a CD, Your Honor.
Is there any objection from the defense?
Yes, Your Honor, we object to hearsay and attorney-client privilege.
All right, let's address the hearsay objection first. Do you have a response to the hearsay objection?
Yes, Your Honor. Pursuant to stipulation 13, Bruce Cohen is stipulated to be unavailable. His statements would be admissible under Federal Rules of Evidence 804B2. These are statements against interest. Under these circumstances, this recording indicates a potential for criminal liability, and under the second prong of that test, the corroborating circumstances would support that criminal liability. Therefore, these statements would be admissible.
What corroborating circumstances have been presented in evidence?
If I may proffer, if we were to go into this recording and the contents of which, it would show an indication that Mr. Cohen was urging Mr. DuPont to secure his rifle as the evidence against Mr. DuPont was unfavorable. And I can provide Your Honor with a transcript of that recording for you to see yourself.
Your Honor, this does not fall under the statement against interest exception, as there is no mention in this transcript by Bruce Cohen of anything that would affect his pecuniary or his proprietary interest. All he's doing here is having a privileged conversation with his client.
Okay, let me ask you to address the privilege objection.
Yes, Your Honor. There is no evidence raised by opposing counsel that Mr. Cohn was in a representative capacity in the scope of representation for Mr. DuPont. And even if he was, these statements would still be admissible under Federal Rules of Evidence 502A, as this was an intentional disclosure.
Tell me more about that.
Your Honor, witnesses just testified that this was recorded on an Amazon Alexa smart home device. The common knowledge of that device is that it records conversations held within its sphere, as that is caused by a trigger word and therefore would be knowledge by the defendant, Mr. DuPont, that his conversations could be recorded by uttering the trigger word. If I were to provide you with the transcript, both the trigger word and the device's proper name are actually mentioned in the first sentence of that recording.
Ms. Burrell?
Your Honor, it's clear that before this conversation began, Charlie DuPont did not intend to activate this device. In fact, if I may make an offer of proof, he stated that he lets the device collect dust on his bookshelf. And he did not have the knowledge about this device to understand that it would pick up this conversation that he was having with his attorney.
Mr. Cohen, I think you failed to lay the sufficient foundation, so at this time that is, it is not.
Your Honor, if I may be heard.
No, you may not. You
Very
can
well.
continue to attempt to lay foundation if you would like.
Agent Riggs, did you issue any search warrants in this case?
Yes, I did. I executed multiple search warrants to locate the hunting rifle as well as obtain any other evidence that could be important in this investigation.
Did you search the defendant's home?
Yes, I searched the defendant's home, and when I was in that home, I noticed that there was an Alexa Amazon Echo smart home device sitting in the middle of the living room, and that was when I obtained a subpoena for Amazon recordings.
Was that device hooked up to the internet?
Yes, it would be hooked up to the internet as it was sitting in the living room plugged in.
Was this readily accessible to anyone in that living room?
Yes, it would have been accessible.
Your Honor, at this time, we renew our motion to admit government, what's been pre-marked as Exhibit 13 as Government's 13.
Ms. Burrell, you stood up. Do you have an objection?
I renew my objection under the same grounds that there has been no foundation laid to overcome the attorney-client privilege that this conversation is protected by.
And so we have, based on that, I'm actually going to defer ruling on that. It sounds like there's going to be some additional evidence coming in. Is that correct?
From this recording, yes, Your Honor. If it is even found that this is attorney-client privilege and that this disclosure was unintended disclosure, this would be covered under 502B. As all three prongs of that test need to be met. The first may be met by unintentional disclosure, inadvertent disclosure. However, parts 2 and 3 of that test have not been met, as it is the responsibility of the holders of that privilege, that being Mr. Cohn and Mr. DuPont, to take reasonable steps to ensure disclosure does not happen, as well as take reasonable measures to prevent that disclosure's effect from coming into court. We have seen no evidence of either Mr. Cohn or Mr. DuPont preventing that evidence to be obtained.
Okay, I understand what your argument is, but since it's the government's case in chief, the defense does not have the burden to produce any evidence at this point. Under your other grounds that you've already indicated, I assume you're reviewing those grounds?
Yes, Your Honor.
I can't help you, sir, but I can tell you, my ruling is that you have not quite laid the foundation to admit the evidence under any of those exceptions.
Yes, Your Honor. So, Agent Riggs, did you discover any discrepancies with what the defendant had told you?
Yes, I had received discrepancies in my interview with him saying that he had previously owned a Winchester rifle and no longer was in possession of one, and then he changed his story within the same interview that I conducted with him to state that he still owns one, but that it had instead been left in Jackson, Wyoming.
So, after noticing these discrepancies, what did you do next?
I executed a search warrant for the hunting rifle, his 1895 Winchester hunting rifle.
Where did you search for that hunting rifle?
The search warrants that I executed in this case were on various locations. In fact, I searched Mr. DuPont's home, his vineyard and winery, as well as his cabin up in Largo.
Would you recognize a map of all of those locations if I showed them to you?
Yes, I would.
Your Honor, let the record reflect I'm showing opposing counsel was pre-marked as Exhibit 33 on page 117 of the record. May I approach the witness?
You may.
Agent Riggs, I'm showing you what's been pre-marked as Exhibit 33. Do you recognize this?
Yes, I do.
What is it?
This is a map of the Northern District of California with the relevant points of interest for this case.
Is it a fair and accurate representation of the Northern District of California with relevant points of interest?
Yes, it is.
Has it been changed or altered in any way since your last review of it?
No, it has not been.
Your Honor, the government moves into evidence what has been pre-marked as Exhibit 33 as Government's 33.
Any objection from the defense?
No objection, Your Honor.
Government 33 is admitted.
Your Honor, permission to publish an enlargement of Government 33 to the jury, as well for the witness to step down to the well to make use of said enlargement.
Those requests are granted.
So Agent Riggs, tell us what we're looking at on this map.
So this is a map of the Northern District of California with the relevant points of interest in this case located on it. Some of those points of interest would be Mr. Sanchez's home right here in American Canyon, as well as the location where Mr. Sanchez's body was found. You can find Mr. Sanchez's body where this green medical bag is located. That would be 4755 Fremont Drive in Sonoma, California. However, there were other indications that were important in this case, such as this blue star here would be DuPont Winery and Vineyards, which is where we executed one of our search warrants, as well as his home in Napa would be in this region here, and his cabin up in Largo, where we also searched for his rifle, would be in this above region.
Why did you search those three locations as opposed to where Mr. Sanchez's body was found?
Well, when we saw Mr. Sanchez's body found at this location, there was bruising on his arms and a lack of substantial blood at the scene. So we had reason to believe that the murder had occurred other than where the body was found.
So Agent Riggs, you searched these three locations. Did you find the defendant's weapon?
No, we were unable to locate his weapon at all.
Did you find any crucial evidence to your investigation from the search warrant?
Yes, we did find a crucial piece of evidence, which was found when we executed the search warrant at the DuPont Winery and Vineyards. On the east side of the property, just off of the property, we found a wooded area with a bullet with no casing on it contained that had blood on top of it.
Agent Riggs, you may retake your seat. Your Honor, permission to retrieve Government's 33 as well as what's been pre-marked as Exhibit 13 from the witness.
Yes.
So Agent Riggs, you just told us that during your search warrant you found a bullet. Where was this located?
This bullet was located in the Northern District of California, just off of the property on the east end of DuPont Winery and Vineyards.
Would you recognize a photo of that bullet if I showed it to you?
Absolutely.
Your Honor, let the record reflect I'm showing opposing counsel what's been pre-marked as Exhibit 16, found on page 101 of the record. May I approach the witness?
May.
Agent Riggs, I'm showing you what's been pre-marked as Exhibit 16. Do you recognize this?
Yes, I do.
What is it?
This is a photograph of the bullet found in that wooded area just off of Mr. DuPont's property.
Is it a fair and accurate representation of the bullet where it was found?
Yes, it is.
Has it been changed or altered in any way since your last review?
No, it's not.
Your Honor, the government moves into evidence what has been pre-marked as Exhibit 16 as Government 16.
No objection.
That is admitted.
Your Honor, permission to publish Government 16 to the jury.
May.
Agent Riggs, you find this bullet in the woods. What do you do with it next?
Well, after finding this bullet and seeing that there was blood on the bullet, I personally took it back to the lab to be processed for any DNA or fingerprints.
Now, you mentioned there was blood. When you tested that, what were the results?
Well, unfortunately, the blood did not yield any results as it had already been exposed to environmental factors for a span of a month, so we were unable to determine whose blood it was.
Did you use this bullet for any comparisons in your investigation?
Absolutely. We used this bullet to compare it to the bullet fragments found inside of Mr. Sanchez's body.
When you compared those fragments to this bullet, what did you discover?
Well, I discovered that both of these bullets were .30 calibers and that both of the bullets had serial numbers on them, starting with the indicator letter H, which would indicate that they came from the same box of
Objection,
ammunition.
Your Honor, hearsay.
Your Honor, this is not hearsay. If I may proffer, the witness will testify that she personally pieced these bullet fragments back together and compared them to the bullets found within the wood.
I think the objection is more to her statement that it means that they were found in the same, that means they were from the same box. Is that correct?
Yes, Your Honor, outside of the presence of the jury, that is both hearsay and speculation by this witness.
Does this witness have foundation to state that as an expert opinion?
Not as an expert opinion, Your Honor. However, Agent Riggs has testified in the beginning of her direct examination that as a homicide investigator, she is familiar with working with forensic evidence. She has a master's in such. She has worked with homicides, which would include gunshot wounds, and has experience working with rounds in this matter, as well as experience knowing certain rounds by their identification numbers, and by personally piecing this information together, she would have personal knowledge to testify to this.
Did she testify about her bullet expertise at the beginning of her testimony?
No, Your Honor, and I would assert that she cannot testify to these specifics, while I don't deny that Agent Riggs has certainly handled bullets and weapons before. Any information she has about the number or letter on a serial number produced by a manufacturer that she didn't speak to is hearsay, and any conclusion she draws about what those numbers or letters mean is speculation.
Well, let's start with the very first issue, foundation. You have not laid foundation in presence of the jury as to this witness's basis for making the statement. So at this time, I'm going to sustain the objection. However, you are free to continue to lay foundation.
Yes, Your Honor. Agent Riggs, earlier you testified as being in the homicide division of the FBI. What are some of the usual duties, procedures that you go through being in the homicide division?
Some of the duties and procedures I would have as an FBI agent and a homicide investigator would be to analyze evidence at the scenes of crimes, take back evidence to the lab to process them for any evidence that could be contained on it, whether it be DNA or fingerprints, or simply observing and taking photographs or documenting evidence of what I observed of those pieces.
And when you observe certain forensic evidence in a case, before making an arrest, what is it that you do?
Before making an arrest, I would observe what was contained in the evidence, and I would analyze it in order to find out what this evidence would actually mean and if it would tie back to any direct links.
Did you produce any documents in this case that would aid in your testimony?
Yes, I would.
And what was that document?
The document that would aid in my testimony would be that I created an affidavit in this case to establish probable cause for arrest of Charlie DuPont.
In that affidavit, do you discuss some of your findings in this case in regards to the bullet in the woods?
Absolutely. I included all of that inside of my affidavit.
And more specifically, what did you include in your affidavit regarding the bullet in this woods and the fragments found within Mr. Sanchez?
I contained in my affidavit that there was a bullet found in the woods and that I compared that bullet to the bullet fragments found inside of Mr. Sanchez. Within my affidavit, I stated that the serial numbers were only 3 numbers off. They began with the indicating letter H, and I mentioned in my affidavit that it came from the same box of ammunition.
I renew my objection for speculation, Your Honor.
Sustain.
Your Honor, if I may be heard, pursuant to stipulation 16 of this record, Agent Riggs has the capacity to testify to her personal knowledge of all facts contained within her affidavit. This fact is found on paragraph 12 of her affidavit.
Does that overcome a hearsay objection to an out-of-court affidavit?
Your Honor, outside of the presence of the jury, the stipulation in this case is to this witness's knowledge of the information, however, it is not to the admissibility of this in court.
That objection is sustained.
Agent Riggs, earlier you testified that you sent this bullet for other tests. What tests resulted from an analysis of this bullet?
Well, from this bullet, other tests indicated that there was a partial fingerprint of Mr. DuPont's on that.
Objection, hearsay.
Your Honor, this would also be contained under stipulation 16 and paragraph 12 of Agent Riggs' affidavit.
And that is about the fingerprints?
Yes, Your Honor.
And what is the objection?
Your Honor, and I'm happy to approach with a copy of the stipulation if you would like.
I have a copy here.
Okay. Your Honor, the objection is to hearsay. The witness is about to elicit testimony outside of the presence of the jury, of course, that the fingerprint on the bullet matched Charlie DuPont. That is something that a fingerprint analyst would have decided and evaluated. We don't have that fingerprint analyst here in court today to cross-examine them on their methods or their results or the reliability of that test, and it is being offered for the truth of the matter asserted.
You said a couple things there. Mr. Cook?
Your Honor, if you'd like, I can lay some foundation to make this admissible pursuant to opposing counsel's objection.
Go ahead then.
Yes, Your Honor. Agent Riggs, when you needed to test this bullet for fingerprints, where did you send it?
I send it to the FBI's investigatory labs.
And who at that investigatory lab would test this bullet for fingerprints?
That would be Emily Genge.
And is it common practice for you as the lead investigator to work closely with Ms. Genge with her reports?
Absolutely. I work closely with the lab technicians such as Emily Genge in FBI-related matters.
And you reviewed Ms. Genge's reports?
Yes, I review her reports as that's very typical in an investigation when it involves a homicide.
What did Ms. Genge's reports indicate to you as lead investigator?
The reports indicated to me as lead investigator that these were typical reports that would indicate the DNA or fingerprints that could be found on a bullet such as this one.
And what did those reports show you?
They showed me a partial fingerprint match to that of this
Objection,
one.
Your Honor, you're saying.
Ms. Genge, legally unavailable.
It's not stipulated under this jurisdiction. However, Ms. Genge is not available to come to trial under this jurisdiction. This is an exception to hearsay under 8036. This is a business record. We've laid the foundation for all prongs of that test.
If I may respond, Your Honor.
Yes, ma'am.
Ms. Genge is not legally unavailable here today, and we do not have her report or her fingerprint testing documents. All we have is this witness's hearsay statement that those documents included this test result, but we don't have the documents themselves, so it wouldn't fall under the business record exception.
Last word?
Your Honor, this would fall under the business record exception as we have laid the proper foundation that Ms. Riggs is a proper witness who can testify to this, even though she's not the custodian of that record. It is common practice as lead investigator for her to work with Ms. Genge in reviewing her reports, that this is a regularly practiced conduct within business. In addition, for any reports to be reviewed, we also have Agent Riggs' affidavit, which this fact is covered and discussed in paragraph 12. And pursuant to stipulation 16, she could discuss that as well. Through combination of those, this would be admissible, Your Honor.
I'm going to allow the evidence that objection is overruled.
So, what did the fingerprint testing reveal to you?
The fingerprint testing revealed to me that on this .30 caliber bullet lied Mr. DuPont's partial fingerprint.
And I want to get back to Ms. Genge as well. Did she do any additional analysis in this matter that she produced to you?
Yes, she also produced testing that indicated that there was DNA found underneath the
Objection, Your Honor,
fingernails.
hearsay.
Your Honor, this is admissible as an exception to hearsay under 8036. This is a business record. In addition, this fact is discussed in Agent Riggs' affidavit under paragraph 12. This is the same argument as the fingerprint analyst.
Since we're in a constructive sidebar, can you tell me what it is the witness is going to say?
She is going to state that Ms. Genge produced a report to her stating that when she conducted an autopsy of the victim following his death on June 5th, she discovered there was skin DNA belonging to the defendant.
And your objection is hearsay because you believe that testimony about identifying the DNA is the hearsay?
Yes, Your Honor, and again, I would assert that this DNA result does not fall under the business record exception because the defense has been provided no documentation of that testing or of Ms. Genge's testing of this DNA, and therefore a simple affidavit that states this result is not a business record exception, and this is not within this witness's purview to speak to the results of a DNA analysis.
Mr. Coven, I'm hearing a discovery objection. What's your response to that?
Your Honor, under 8036, there is no element needed that the opposing counsel needs to review these statements. In addition, Agent Riggs' affidavit is contained within this record.
The objection is sustained as to the DNA.
So, Agent Riggs, once you found out the bullet had the defendant's fingerprint on it, what did you do next?
After I found out that there was a partial fingerprint on this bullet, and along with all the other evidence that I had formed in this investigation, I was able to establish enough probable cause to arrest Mr. DuPont for destruction or alteration of evidence, as well as for murder in the first degree.
No further questions, Your Honor. Permission to retrieve government 16 from the witness, as well as for the witness to be, apologies, just permission to retrieve government 16.
Please go ahead.
Would the opposing counsel like to make use of our diesel or demonstrative on
No,
cross-examination?
thank you. If you'd like to take it down, feel free.
Absolutely.
Ms. Morel, your cross-examination.
Yes, Your Honor. Good morning, Agent Briggs.
Good morning.
I want to start by talking about what you knew and what you didn't know when you began this investigation. You didn't know Mr. Sanchez, the victim, when you became involved in this investigation,
No, I did not.
but you did know Charlie DuPont.
I knew him from around the community, yes.
You were actually a member at the DuPont Family Vineyard,
Yes, my wife and I would go to the vineyard and try their wines constantly.
and you had seen Mr. DuPont at the vineyard before.
Yes,
You believed that Mr. DuPont was an arrogant man.
yes, I believe that he was arrogant and wanted his money in front of the customers.
You believed he was unbearable.
Sure.
So when you began your investigation into the murder of Ignacio Sanchez, you quickly made this arrogant, unbearable man your prime suspect.
It wasn't at the very beginning of the investigation. I waited until after I had collected some evidence after my interviews. At the beginning, he was simply a person of interest.
You waited until after one interview with him to name him your suspect.
It was after my interview with him that I knew he was a suspect.
Now I want to talk about some of the conclusions you quickly drew when you became involved with this case. You decided that Mr. Ignacio Sanchez was not murdered at 4755 Fremont Drive.
Yes,
And that, just so that the jury is clear, is the location where his body was discovered, right?
yes it is.
Because of the lack of pooling of blood underneath of his body, you believed he had to have been moved.
Along with that and bruising on his arms.
But the lack of blood was one thing that made you believe that he'd been killed elsewhere.
Yes, it was one of the factors we considered.
Now, you didn't go inside of the house at 4755 Fremont Drive to see if Mr. Sanchez's blood was in there, did you?
No, we did not, as Mr. Sanchez was found outside of that property.
Not only did you not go inside of the house where his body was found in the front yard, you didn't even talk to the owners of that house.
No, I was not the person that initially investigated that scene of the crime. That would be the local authorities.
Well, you came onto this investigation just about a week later, correct?
Yes, I did.
And just about a week later, when you became involved, you could have gone to that help.
It wasn't necessary for our investigation as he was not found within that home.
So because Mr. Sanchez was found on their front yard, you just ruled them out.
I did not find it necessary to go inside of that home